My name is Kim Stanger. I'm the head of the Holland Hearts Health Law Group. And today we're going to be talking about responding to non-compliant situations, specifically curing, reporting, and repaying any overpayments that you might receive. A couple of disclaimers. This is a quick overview of the relevant federal laws and regulations. They're not necessarily, this presentation is not necessarily comprehensive, especially when it comes to state laws, because your state laws may have your own report and repayment obligations. Application of these laws may depend upon your particular circumstances, of course, including the payers involved. If you're dealing with government payers, then you're probably going to have to consider these rules and laws that we're going to talk about today. But they might also apply in some situations to private payer situations. It could also vary depending upon the particular jurisdiction that you're in. So when it comes time to actually applying what we're going to talk about today, make sure that you pull out the laws, the rules, check it against your particular facts to ensure that you respond appropriately. With that said, let's get into it. When it comes to non-compliance, whenever you want government money, it always comes with strings attached. That means that if you want to get paid by the government, you got to comply with their rules, their conditions of payment or participation, their fraud and abuse laws. And if you fail to comply with that, then you are not only violating the False Claims Act, but you may have an affirmative obligation to report and repay any amounts that you have received improperly. That can be implicated by any number of the federal fraud and abuse laws. We talked about all of these a couple of weeks ago. That webinar is recorded. So if you want more information about these federal fraud and abuse laws, including the False Claims Act, the Anti-Kickback Statute, Stark, ECRA, etc., then you can go back and listen to that program. For purposes of today, though, we're going to talk about what are the remedies, what happens if you fail to comply with those laws. Well, under the False Claims Act, it not only prohibits you from knowingly and improperly submitting a false claim to the government, but it also says that if you received a payment improperly, that it prohibits you from knowingly and improperly avoiding an obligation to pay or transmit money or property to the government. Obligation is defined as a duty to repay the government arising from a statute or contract or retention of any overpayment. So if you've been paid improperly, then that's an overpayment, and you can be liable for the False Claims Act violation if you fail to report and repay that back to the government. What are the statute of limitations? Well, it's generally 6 years from the time that the false claim was submitted, or if you failed to pay amount that was due to the government from the time that you failed to pay, or 3 years from the time the government knew about it, but no more than 10 years from the false claim. So it can be told for a period if the government doesn't know about it. What are the penalties if you fail to comply with the False Claims Act obligation to report and repay? Well, it can be in addition to the amount that you have to repay, you can get hit up with an additional approximately $25,000 per violation. Note that that's per claim that you submitted. So if you've got a long history of submitting improper claims, or you had a billing mistake and it impacted 1,000 different claims, well, that's 1,000 different potential penalties that you could get hit up for. In addition, you can be liable for treble damages incurred by the government, the cost of litigation. You could also be subject to a qui tam lawsuit, assuming qui tam lawsuits are still constitutional, because there was a federal court case a couple of months ago that came down and declared the qui tam lawsuits unconstitutional. We don't know exactly how that's going to play out, so stay tuned on that. But in the meantime, you got to be concerned about the government coming after you. Now, that's the False Claims Act. There's a separate statute, the Civil Monetary Penalties Law, states that if a person has received an overpayment, they've got to report and repay that relevant overpayment to the government, to the relevant government agency, the fiscal intermediary or contractor, within the later of 60 days after the time that the overpayment is identified, or if you're getting paid based on a cost report, the date that the cost report is due. That also has a 6-year look-back period, a 6-year statute of limitations. What happens if you violate the Civil Monetary Penalties Law? Well, again, you can get hit up with penalties of about $25,000 per violation, plus treble damages. You can also be excluded from participating in Medicare or Medicaid, which is kind of the death knell of practicing healthcare in the United States these days. So those are the general statutes that you got to be most concerned about. Let's talk about how if you do have a problem, what the report and repayment process is. Well, there's a specific CMS report and repayment rule that we'll talk about. That applies if you're just going to go back to the contractor and repay your Medicare contractor. There's also the self-disclosure protocol under the Federal Stark Act and the OIG self-disclosure protocol that would apply to the anti-kickback statute or civil monetary penalties laws. Let's talk about each of those. First, the CMS report and repayment rule. This rule implements the civil monetary penalties law, that law that requires you to report and repay within 60 days. It states that a person that has received an overpayment must report and return the overpayment in the form and manner set forth in that regulation. The regulation states that a person who has received an overpayment must report and return the overpayment by the later of either of the following: the date, which is 60 days after the date on which the overpayment was identified, or the date any corresponding cost report is due, if applicable. Again, tracks the language in the civil monetary penalties law. Well, what is an overpayment then? Well, the statute defines overpayment as funds that a person receives or retains to which the person, after applicable reconciliation, is not entitled. So you got paid money that you shouldn't have been paid. Examples might be if you receive payment for non-covered services, the payments were in excess of the allowable amount, the errors and maybe it resulted from errors and non-reimbursable expenses and cost reports. Maybe you got duplicate payments, receipt of Medicare payment when another payer is primary, payments received in violation of Stark, the anti-kickback statute, exclusion statute, and the like. They prohibit you from billing the government for those services that were rendered per an improper referral. And if you did and got paid for it, you've got an affirmative obligation to report and repay. That's an overpayment. There is no finder's keeper in this situation, right? If you know that you got paid improperly from the federal government, then you've got to fess up and you've got to report and repay it back to the federal government. There's just no finder's keepers. Under the report and repayment rule, it's got a 6-year look-back period, so an overpayment must be reported and returned in accordance with this section if a person identifies the overpayment within 6 years of the date the overpayment was received. So if you go along in blissful ignorance for longer than 6 years, well, it's only a 6-year look-back period, so you probably should be okay. If, on the other hand, you want to just play it sly and you want to just wait and see if the government catches you within that 6-year period, well, it still operates like a statute of limitations. It's still a 6-year look-back period, but there's risk, right? You could have liability, if not under this statute, perhaps on a separate statute, maybe for fraud and the like, even if they can't come after you under the civil monetary penalties law. In addition, during that 6-year period, you got to be worried about looking over your shoulder, because not only may the government come after you, but it all may be that you may have a key tam relator, somebody that goes in and sues you on behalf of the federal government to recover. Well, the report and repay rule only applies if you knowingly fail to report and repay by the deadline. Okay, that's 60 days or the date that the cost report is due. Well, what does knowingly mean? Well, under the False Claims Act, knowing and knowingly means you have actual knowledge of the information, or you act in deliberate ignorance of the truth or falsity of the information, or you act in reckless disregard of the truth or falsity of the information. And that does not require specific proof of intent to defraud. So even if you did not know what you were doing was wrong, if you knew or should have known, you acted in reckless disregard or deliberate ignorance of the truth or falsity of the facts and your obligations, then in that situation, it could trigger the knowing requirement and subject you to penalties if you fail to report and repay. Well, you've got to report and repay generally within 60 days after the date on which the overpayment is identified, or the date the cost report is due if you're paid under that. As far as the 60-day time period, when is it identified? When's the overpayment identified? Under the current report and repayment rule, it states that a person has identified an overpayment when the person has, or should have, through the exercise of reasonable diligence, determined that the person has received an overpayment and quantified the amount of the overpayment. So it's not only that 60-day time period runs from not just when you knew that there was a problem, but you've also investigated and quantified the amount of the overpayment, so you've determined how much money you've got to repay to the government. In the rule, it states that a person should have determined that the person received an overpayment and quantified the amount of the overpayment if the person fails to exercise reasonable diligence and the person in fact received an overpayment. So you can't just sit back on this thing and think, well, I'm just never going to investigate then. because the government says, hey, if once you got word of that, then you're obligated to take reasonable action. And if you don't do anything about it, then you are acting with the deliberate and in deliberate ignorance. In that situation, you knew or should have known, and therefore you could be liable, and the time period would have run. Well, under the current rule, under the current regulations, an overpayment is identified if you have either actual knowledge or should have known through the exercise of reasonable diligence. In the commentary that accompanied the new report and repayment rule, they specifically said that you exercise that reasonable diligence through proactive monitoring and reactive investigations. So not only are you bound by what you actually knew, but the government expects you to do proactive monitoring. And if you fail to do that, then you could have been determined to act without reasonable diligence, and therefore you may be deemed to have known and identified the overpayment. So it's not only that you have to respond, but at least according to the commentary that came out, they expect you to do some kind of proactive monitoring in order to be acting with reasonable diligence. The government gave some examples. For example, providers have a duty to investigate if you receive credible information of a potential overpayment. For example, significant and unexplained increase in your Medicare revenue. So suddenly you're getting more money than you thought you should have. Maybe there's a problem. If a review of your bills shows that you did use incorrect codes, if you discover services were rendered by an unlicensed provider, or an internal or external audit discloses overpayments, or you discover that there's an anti-kickback statute, Stark, or civil monetary penalties law violation, then you probably have an overpayment, and that triggers your obligation to go ahead and investigate, determine the amount that's overpaid, and at the time you determine the amount of the overpayment, then that 60-day time period will run. That is under the current rule. Now in 2022, the government issued a proposed rule. It's still out there pending, hasn't been finalized yet. But under the proposed rule, they would modify that reasonable diligence standard so that it's no longer a reasonable diligence standard, but instead it would apply if you act in reckless disregard or deliberate ignorance of the overpayment. The reason they proposed this rule was it aligns more closely with the False Claims Act, and it responds to a 2018 case in which the court held that reasonable diligence standard improperly made providers liable for negligence instead of the standard in the False Claims Act, which is knowing, which is defined as acts in reckless disregard or deliberate ignorance of the overpayment. So we anticipate that the new standard will take effect sometime. We just haven't got the final rule on that yet, so we'll have to watch that. Also under the 2022 proposed rule, so the net effect of that is under the 2022 proposed rule, a person is determined to have been identified in overpayment when the person knowingly receives or retains an overpayment. That is, they either have actual knowledge of the information that there was an overpayment, or you act in deliberate ignorance or of the truth or falsity of the information, or act in reckless disregard of the truth or falsity of the information. So it replaces that reasonable diligence standard under the current rule with this actual knowledge, deliberate ignorance, or reckless disregard of the truth. Under the current rule, as it currently exists, once you are deemed to be put on notice that there's a problem, you have up to 6 months to investigate, and then at the end of that, you would have that 60 days to do the report and the repay. Under the current rules, in the commentary that accompanied it, CMS concluded that the provider must show reasonable diligence, which they determined to be that it's a timely, good faith investigation if you have credible information that there's a problem. And they said that, hey, you ought to be able to conclude that investigation at most 6 months. That doesn't necessarily mean that you've got 6 months. It just means that you've got to act with reasonable diligence, but it shouldn't be longer than 6 months, except in extraordinary circumstances. And extraordinary circumstances are not just that you never got around to it or you were really busy, but it involves things like complex investigations, natural disasters, or a state of emergency. If you are going to take a while to do your investigation, you're going to want to maintain documents to show that you acted with reasonable diligence. Now in 2024, this year, the government has proposed a second revision to the report and repay rule, which modifies that time limit for doing the investigation. So under the current rule, right, you've got the time limit is triggered once you determine the amount of the overpayment, and you've got like up to 6 months maybe to do the investigation to determine that amount. Under the new proposed rule, it would change that. So it would say that, hey, you've still got to do that report and repay within 60 days. It's still a 60-day time limit, but it will suspend the time limit for doing that report and repay, the 60-day time limit, suspends for a period of up to 180 days, so long as you engage in a good faith, timely investigation. So assuming that that you've not completed an investigation, you conduct a timely good faith investigation, then the time for reporting is told up until the later of the following, or the earlier of the following. Either the date the investigation of the related overpayments is concluded and the aggregate amount of the initially identified overpayments and related overpayments is calculated, or the date that is 180 days after the date on which the initial identified overpayment was identified. So the way, again, that it works is you've still got that, presumptively, you've got to do the report within the 60-day time period, but that 60-day time period is told while you do an appropriate, timely, good faith investigation. But that time limit ends once you conclude that investigation, or the earlier of either when you conclude that investigation to determine the amount that's due, or 180 days has passed. So you've only got up to 180 days. The government gave an example under the proposed rule. So, for example, on day one, a person identifies an overpayment arising from a physician's failure to properly document the medical record to support the coding of a specific claim. And the person has reason to believe that this may be a common practice of the physician, so there could be more affected claims. At that point, you're put on notice, right? At that point, the person has up to 180 days to conduct and conclude a good faith investigation to determine whether related overpayments that arise from the same or similar cause or reason as the initially identified overpayment exist. So you've got the 180 days to do your investigation. If the person does not conduct an investigation, or the investigation is not timely or not conducted in good faith, the identified overpayment must be reported and returned by day 60. On the other hand, if you do initiate a timely and good faith investigation, then that suspension of that 60-day period, it's suspended of the report and return obligation beginning on day one, and it ends when the investigation is concluded and the initially identified overpayment and related overpayments, if any, are calculated, or by day 180, whichever is earlier. The overpayment must be reported and returned within 60 days after either completion of the investigation or day 180, whichever is earlier. Now, again, this is the proposed rule. It's not the final rule, but it pretty much aligns with kind of what the rule is right now. The bottom line there is, if you think you have a problem, you've got to act on it. You've got to do a reasonable investigation to determine whether there is an overpayment obligation, and if so, the amount of that overpayment. And if you fail to do a timely investigation, then guess what? You can get hit up with those penalties. Now, that deadline for reporting the overpayment is suspended. That 60-day time period is suspended if you go into either the OIG self-disclosure protocol or the STARK self-referral disclosure protocol, or if you go to the contractor and like your fiscal intermediary, and you agree with them that that they will give you an extended repayment schedule. To go ahead and do that report and repayment to the federal contractor, you generally use the claims adjustment, credit balance, or self-report refund, or other reporting process set forth by your Medicare contractor. So if you go to your Medicare contractor website, whether it's Noridian or some other entity, they should have a section there that talks about reporting repayments or reporting overpayments, and it should tell you the process that they want you to go through and use that. If you are going to use a statistical sampling, you've got to describe the methodology that you used when you do the report to that contractor. If the settlement is reached through the OIG self-disclosure protocol or the STARK self-referral disclosure protocol, then you've got to comply with the reporting requirements that are set forth in that settlement agreement. So, for example, for Noridian, This was one I just called up. You can go to the website. They have a particular page that talks about the overpayment and recoupment process, and you would just want to follow that. Note that if you are going to go through that report and repayment process with your Medicare contractor under the CMS report and repay rule, that's good. It's probably the safest thing to do, but it's not going to resolve violations of penalties under other laws, like the anti-kickback statute, civil monetary penalties law, or False Claims Act. Those are all handled by the OIG and or the DOJ. So just because the contractor accepts that repayment doesn't necessarily mean you're protected by action by the OIG or DOJ. When it comes to Stark, Stark is enforced by CMS. So again, no matter what you do with the contractor, it's possible that CMS may come after you for a Stark law violation. If you believe that repayment involves a violation of federal law, then you may want to report the repayments to the OIG, CMS, or other federal agencies so that you get it resolved. All right, so let's talk about some of those specific situations. First, let's talk about if you've got a Stark problem. We talked about what Stark is. That generally prohibits referring or submitting claims for payments that were referred by a physician with whom you have a financial relationship for certain designated health services, unless you've structured the transaction to fit within a relevant safe harbor. Under the Stark law and the regulations, it prohibits the government from paying any payments for designated health services that were furnished by a referral from a prohibited referral under Stark. And if you were paid improperly, then the Stark regulation says that an entity that collects payment for a DHS that was performed pursuant to a prohibited referral, you've got an affirmative obligation to refund all amounts on a timely basis. That is within the 60-day period from the time the prohibited amounts are collected by the individual or entity. Note that Stark is a strict liability statute. Your intent doesn't matter. So under Stark, if you were paid improperly, then you've got an affirmative obligation to report and repay that money back to the federal government. If you fail to do that, well, that would be a False Claims Act violation, so you could get hit up with those penalties we already talked about. In addition, you could get up to certain penalties under Stark, which currently is about $31,000 per violation, per claim. In addition, you can get hit up with treble damages. You can be excluded from Medicare and Medicaid and be subject to all the other penalties under the False Claims Act and civil monetary penalties laws that we discussed. If you think you might have a Stark violation, you need to look at it, right? You need to determine whether or not there actually was a violation. In order for there to be a violation under Stark, there had to be a financial relationship between a provider of designated health services and a physician or a member of the physician's family. That physician had to refer DHS to the provider, and no safe harbor applies. Stark has a whole bunch of safe harbors or exceptions. If you fit within the exception, then you're fine. If you don't fit within the exception, then you likely have a violation if there's been a referral for designated health services by a physician. When you're looking and analyzing your Stark compliance, Stark is fairly complex. I spent a good deal of my time dealing with Stark issues. You not only have to look at the safe harbors, but you also have to check the definitions. You have to check the special rules concerning compensation, such as those that might apply to indirect compensation arrangements, grace periods, certain amendments that they will allow, things like that, before just automatically concluding that there was a violation. I wanted to point out that in 2021, CMS added a reconciliation rule in Stark. I think that they were concerned or tired of getting a bunch of Stark self-disclosures for situations where somebody was overpaid or underpaid, and so it was a technical Stark violation, which means that you got to repay the government. But the government said, look, as long as you fix it within a certain time period, we don't care. That's not going to be deemed a Stark law violation anymore. So under the new rule, Stark allows parties to remedy an overpayment or underpayment situation if this is a situation where you paid a provider, a physician, more than they should have been paid, or underpaid them, something like that, as long as you correct that situation no later than 90 consecutive calendar days following the expiration or termination of the compensation arrangement. So within that 90-day period after the termination of the agreement, the entity and the physician or immediate family member reconcile all discrepancies in the payments under the arrangement such that following the reconciliation, the entire amount of remuneration for items or services has been paid as required under the terms and conditions of the arrangement. If you do that reconciliation such that you've got all of those overpayments or underpayments resolved within that 90-day period, then it's no longer a Stark Law violation. You don't have to report or repay those situations. When you're looking at the Stark Law violations, make sure that you take a special look at what are referrals and what are DHS, because remember, Stark's only triggered by referrals for designated health services, and it may be that you really don't have an improper referral, or there's no referral for designated health services under the definitions. For example, in 2021, they clarified the definition or modified the definition of designated health services so that designated health services no longer include services furnished to inpatients by a hospital if it's payable by Medicare under the prospective payment systems, one of the following prospective payment systems. So that's a change that may help you who are hospitals who are trying to deal with Stark Law violations. If you want to know how to do the self-disclosure protocol, you conclude that, yes, in fact, we do have a Stark Law violation, we do have an affirmative obligation to report and repay, well, then you're probably going to want to use the Stark self-referral disclosure protocol. You go ahead and access that at the government Stark Law website. And there are benefits and also disadvantages to using that self-disclosure protocol under Stark. The benefit is it suspends that 60-day report and repayment requirement while you work through the SRDP. The real benefit is CMS will likely reduce that repayment obligation significantly if you fully cooperate in a timely manner. In addition, if you've done this self-disclosure, it may preclude a qui tam lawsuit, so it may avoid a situation where a third party comes in there and sues you because you beat them to the government to report this potential problem. And it allows you to finally resolve the issue. If you just do the repayment to the contractor, which, by the way, I would recommend in most cases, but if it's a pretty serious, significant issue, if you do the Stark self-report, then you know the issue is resolved at least with CMS, and you don't need to worry about it or worry about the government coming back after you. Well, what are the downsides doing for going in the self-disclosure protocol under Stark? Well, there's no guarantee that the government's going to reduce the penalty, but in every situation I've seen, they've always reduced the penalty. It's possible you may be subject to additional penalties if you do not fully cooperate in the investigation. CMS may broaden the investigation. Maybe you report violations in this manner, but in the course of that investigation, CMS identifies other problems. So they may start pulling the string and unwinding your organization. If you are going to do that disclosure, then you're probably going to waive privileges that may otherwise apply. When you go do the Stark self-disclosure protocol, you're basically admitting that there's a liability, that you did violate it. It may toll the FCA statute of limitations so that 6-year period doesn't run during the 6 years. It's tolled while you're in the self-disclosure protocol. And there's no guarantee that CMS may not refer you on to DOJ or the OIG for violations of, say, the False Claims Act. Nevertheless, in my experience, CMS has actually been pretty good to deal with when it comes to the Stark self-disclosure protocol, so I'm a big fan of the Stark self-disclosure protocol. The government, if you go to that website, it has the document that you use to do the self-disclosure protocol. It walks you through the process. You can access that website. If you're going to use that for a Stark violation, you should only use that program when you know that there is a Stark Law violation, because when you're submitting that, you're essentially admitting that, yeah, we've got a problem. You don't do that in order to ask the government if there's a problem, right? You want to know whether the government would come after you if there's a problem, then Stark has a separate advisory opinion process that you can go through. If you're going to the Stark self-disclosure protocol, you're basically going to them and saying, yeah, we violated it. This is how much we got paid improperly. What are you willing to receive? If you do go to that Stark self-disclosure protocol, you don't make any repayments while the protocol is in place, while the process is going on. Following the submission, after CMS looks at all the information you got, maybe requests some additional information, then they will come back to you and propose a settlement. Now, in my experience, this is a take it or leave it. This is not a negotiation. They'll come back and say, we've looked at it, pay us X dollars. in the past, CMS has been willing to settle for in the, I don't know, 5 or 6 or 7 or more disclosures that I've done. CMS has always been willing to settle for 1 to 3% of the potential repayment exposure. So it really is a pretty good deal if you can go through it. Now, I haven't done that for a couple of years, so I'm not sure whether their current stance is, but from everything that I've seen, they're still looking at that. Especially because STARK can result from technical, non-intentional violations, but the government is willing to be pretty reasonable when it comes to that potential repayment exposure. If you are going to settle, then the settlement is a settlement and you're waiving your appeal rights. If you decide that you don't like the amount that the government wants back, then you don't have to accept it. In that case, you would withdraw from the self-referral disclosure protocol and all bets are off. You could be liable for False Claims Act violations. The government may or may not decide to go ahead and continue to pursue you, but you don't get the benefits of the self-referral disclosure protocol. The government has indicated when in determining the amounts that they're going to require you to repay, they consider factors such as the nature and extent of the improper or illegal practice. Was this a one-time situation or is it a pervasive situation? What was the timeliness of the self-disclosure? As soon as you learned about it, did you respond, or has this been going on for a long period of time? Did you cooperate in providing additional information related to the disclosure? Although CMS may consider these factors in determining whether the reduction in any amounts is owed, CMS has specifically reserved the right to not reduce any amounts due and owing, so there's no promises, but like I said, in all of my experience, they've been pretty good to deal with, and they've always given a pretty good deal on the self-disclosure. If you look at the amounts, in 2022 and 2023, there were backlogs. I think that I had some cases that have been pending there for 6 or more years. In 2022 and 2023, the government was actively engaged in trying to get a bunch of those resolved. And so you'll see there was a big spike in the number of cases that were resolved based on additional guidance that they came out with in 2021 that would allow you to evaluate your STARK compliance in light of this additional guidance, and if you wanted to voluntarily withdraw because now, based on the additional guidance, you concluded that there was no violation. All right, that is the STARK self-disclosure protocol. Let's talk about the OIG self-disclosure protocol. The OIG is not nearly as friendly and fuzzy or warm as CMS is when it comes to dealing with this situation. The OIG enforces, the Office of Inspector General enforces various federal fraud and abuse laws dealing with HHS, including the anti-kickback statute, civil monetary penalties law, the exclusion authorities, healthcare fraud, information blocking rule, and others. It does not handle STARK violations. STARK is handled by CMS, but the OIG handles these others. Most of these statutes, unlike STARK, are intent-based, so the standard is whether you knew or should have known of the facts resulting in the violation, but it's kind of hard to disprove that you knew or should not have known that there was a violation. And the test is not whether you knew that it violated the law. The test is whether or not you knew that what you intentionally did the act, whether it was in violation of the law or not, whether you knew it was in violation of the law. When it comes to the anti-kickback statute specifically, the courts have said that if you don't fit within the scope of the safe harbors under the anti-kickback statute, the test becomes there's one purpose of this remuneration to induce or reward referrals. If so, that it's an anti-kickback violation, and that's a hard standard to defend against. The OIG's published their self-disclosure protocol. You can go to it and access at this page. Again, like the SRDP, this OIG self-disclosure protocol has pros and cons, right? The benefit is it suspends that 60-day report and repayment clock while you work through the self-disclosure protocol. The OIG may reduce penalties if you fully disclose and cooperate, but that doesn't mean you're going to walk. It's not like they're going to reduce the amount of the repayment. That's not kind of where they're going on that. The OIG said that they may reduce the penalties from 2 or 3 times or treble damages down to 1.5 damages. They've indicated in their self-disclosure protocol that the minimum amount that they would accept would be $20,000 in the case of an anti-kickback violation. The minimum amount they're going to accept is $100,000. So if you're going to walk into a self-disclosure protocol with the OIG, know that you are going to be paying money, and significant money. One of the other benefits is if you go through an act in good faith and go through the self-disclosure protocol, the OIG may, but is not necessarily required to, forego a corporate integrity agreement or other exclusions. And those can be pretty draconian and pretty costly to do those corporate integrity agreements. So it is a benefit. It may preclude key TAM lawsuits, again, because you've narked on yourself rather than a third party narking on you to the government. Well, what are the downsides? Well, again, there is no guarantee that the OIG will reduce penalties or reduce penalties significantly. Again, if you go through the SDP, you're going to pay money, and potentially a significant amount of money. It just may be that you don't pay as much as you might not have to pay if the government catches you otherwise. The OIG may broaden the investigation. Once they get in there, they could find other things and come after you. Anything that they discovered, additional that they discovered, are going to be outside the SDP, and so you're not going to get the benefits of the SDP. Failure to fully disclose or cooperate may result in additional penalties. So if you're going to go into this, you need to go into it in good faith and wholeheartedly, because if they conclude that you're not cooperating with them, then they can come out and drop the hammer on you. The OIG may report to the DOJ or other government agencies. Participation with the OIG is usually quite a bit more burdensome than the SRDP. They may require you to waive the 6-year statute of limitations period, and you may be, any disclosures you make to the OIG may be subject to a FOIA request. So if you're going to go the SDP route, just beware of the potential consequences. There are cases and situations where you really haven't got a whole lot of choice, and it's better than potentially ending up in jail. But just realize, think through the appropriate process. If you look at some of the OIG or the OIG SDP recent settlements, I mean, look at the amounts there, right? $291,000, $10 million. You're going to probably pay, 5, 6, 7 digits if you're going to go to the OIG. To get the protocol, all you got to do is go to the OIG's website. They've got their handbook that talks about the OIG process, the self-disclosure process. It provides the information that you've got to submit and the like. That self-disclosure protocol to the OIG is really appropriate for violations of the federal, criminal, civil, or administrative laws for which civil monetary penalties are authorized. If it's just simply a situation where there was a relatively innocent overpayment, no long-going pattern, then you're probably fine and safer just doing the report and repay to CMS, the fiscal intermediary, under the report and repay rule rather than going through the self-disclosure protocol. On the other hand, if you think that you've got serious problems, then you may want to do the self-disclosure protocol. If you're going to enter into that, make sure that you ensure that the prohibited conduct is ended, right? Don't keep doing things that are wrong, right? After you go into that self-disclosure protocol. The specific requirements for the protocol depends on the nature of the violation, whether it's false billing, whether you're dealing with an excluded individual situation, or an anti-kickback violation. The disclosure protocol will have different requirements. The government has warned that the benefits of self-disclosure, such as speedy resolution, lower multiplier, and exclusion release without integrity agreement obligations, depend on the disclosing party's willingness to work cooperatively with the OIG through the process. Cooperation includes, for example, conducting a thorough investigation, submitting all necessary information, communicating through a consistent point of contact, being responsive to OIG requests for additional information, and being willing to pay a penalty or multiplier of damages for self-disclosed conduct. Disclosing parties who fail to cooperate with the OIG in good faith will be kicked out of the SDP, and all bets are off. So, like I say, if you're going to go into the self-disclosure protocol, make sure that you go in there whole hog and that you're willing to cooperate and know that you're going to be paying money. Another alternative is to skip the OIG and just go directly to the Department of Justice, but the Department of Justice, this really isn't their bailiwick, and they may not, really don't have an established self-disclosure protocol process. The benefit is the DOJ does have authority to settle most types of claims, and they can do it kind of finally. And it may be that your local U.S. attorney may be a little bit more sympathetic to you than maybe the OIG may be, but who knows? The downside is, remember that if you go to the DOJ, they're in the business of prosecuting entities. The DOJ is really not a known commodity, so it's not like we have any kind of guarantees about what their process is. At least with the OIG, we've got their self-disclosure protocol that we kind of have parameters of what they do, but you really don't know what you're going to get if you go to the DOJ. And all right, That's a summary of the federal laws. Remember that states may have their own laws. In fact, most states, as far as I know, in their Medicaid rules and regulations, they do have a similar report and repay obligation that requires you to report and repay back monies involving Medicaid. They will also have their own fraud and abuse laws, like the anti-kickback statute, maybe mini Stark laws, fee splitting statutes, and the like. You just need to make sure that you're aware of your state law requirements in addition to the federal statutes. Okay, let's talk about what you need to do then. Of course, better than a repayment situation is to practice preventive medicine, right? Make sure that you don't have a violation of the law so that you never have to get in a repayment situation. Along those lines, make sure that you understand the relevant fraud and abuse statutes, including those high-risk issues that are identified by the OIG that can result in repayment situations, such as coding and billing issues, violations of the anti-kickback statute, Stark, civil monetary penalties law, state fraud and abuse laws. The government has published a lot of resources talking about those laws. I've given you a few up there on the screen that you can go to if you want more information about those laws, or you can go to the webinar that I did a couple of weeks ago talking about those laws, or a bunch of other resources that we've got for free on our website. You can access that. Next, you're going to want to make sure that you implement an effective compliance program. The compliance program is important for two reasons. One is if you've got an effective compliance program, it may prevent you from actually violating the law. Surprise, surprise. And even if you do violate the law, then the OIG will consider whether if you've got an effective compliance program as a mitigating factor, or at least it may do that when it comes to imposing penalties. As you know, in November of last year, the government issued its new general compliance program guidance. You can go to the government's website, the OIG's website, you can download that, and you'll probably want to compare that against your current compliance program to make sure that that your current compliance program meets the standards that the government has outlined in that guidance. You're going to want to train your key personnel concerning relevant laws. Key personnel are going to be things like your administration, compliance officers and committees, but also human resources, physician relations and medical staff officers, because they may impact Stark or others, marketing and public relations. Here's a word of warning to you. Your marketing and public relations departments probably don't understand these things, and things they can do that they were trained on in college and the like, that they can do in other industries, they cannot do in the healthcare industry. So make sure that they're aware of the fraud and abuse laws and the other limitations. Governing board members, purchasing, accounts payable, billing and coding, certainly you need to make sure that they're trained on the relevant laws. Make sure that you document the training so that you can show that you acted in good faith. And then review and repeat, right? One time is not enough. You should have some kind of probably annual training to make sure your people are aware of the laws, especially as you've got turnover, to avoid the types of problems. You should check and periodically audit financial relations with physicians and other referral sources if the referrals involve government healthcare programs, because those are the types of situations that are going to involve Stark, anti-kickback, civil monetary penalties law, ECRA, the Eliminating Kickback and Recovery Act. Just a word about ECRA. Remember that ECRA not only applies to government payers, but also private payers. So if you operate a lab, then you better make sure that your financial relationships, benefits you're offering to patients and the like, comply with ECRA. Otherwise, you could be in trouble under ECRA, even if it's just private pay. Some of the things you want to look at are employment and services contracts to ensure they comply with the relevant safe harbors and statutes and regulations. Your group compensation structure, if you're a group, beware eat what you kill, because there are limits on what you can do or how you can set that up. Recruitment arrangements, joint ventures or investments, leases for space or equipment, free items or services or perks or other gifts to referral sources, discounted items or services, loans, or any other remuneration that you're given to a potential referral source. You should consider and document compliance with your Stark and anti-kickback exceptions. After you've looked through that stuff, you're going to want to probably document fair market value, which is not the only factor, but it's a significant factor and common factor in a lot of the Stark and anti-kickback statute exceptions. Commercial reasonableness, legitimate basis for the actions such as community need, patient care, and not just to do a deal in order to generate referrals. Make sure that you perform consistent with contract terms, because if you fail to do so, then maybe you're not really complying with the relevant regulations. Beware situations where you fail to satisfy all the regulatory requirements, because for most of these, to get the benefit, you got to satisfy all the requirements, and close is not enough. If one purpose is to generate referrals for items or services covered by federal healthcare programs, well, you better fit within a safe harbor, or else you got to be concerned about the anti-kickback statute. Beware that you monitor these ongoing over time, because circumstances may change over time. And so you need to make sure that you stay on top of it so that you can avoid situations where suddenly you're out of compliance because people really weren't paying attention. If there is a problem, you need to respond promptly to the non-compliance. In the compliance program guidance, they specifically say it's important that the compliance officer act promptly to notify appropriate leaders and coordinate with entity counsel as needed upon receipt of reports or reasonable indications of suspected non-compliance to determine whether a material violation of the applicable law has occurred. Don't hide your head in the sand. Remember the report and repayment requirements. They apply if you knew or should have known, right, that there was a violation. And if you don't act with reasonable diligence, then that 60-day time limit for reporting and repaying kicks off immediately. So you're going to want to respond immediately. And it's going to limit the amount of damages that you might have to report and repay. Make sure that when it comes to responding to compliance, make sure you know and comply with your compliance program. Presumably you've all got compliance programs. It should tell you how to respond. If you fail to respond to your compliance program, you're probably not going to look very good, right? So make sure that you understand and know your compliance program. Don't panic or overreact. It may be that there is no violation. A lot of these laws are pretty technical. There are safe harbors. There's some advisory opinions out there. So you're going to want to look at it and do an appropriate analysis with somebody who's qualified to really determine whether or not there really is a problem. If you do think you've got a problem, then make sure that you suspend relevant claims until that situation's resolved. It's one thing to submit the claim when you didn't know that there was a problem. It's another thing to know or should know that there's a problem and go ahead and to continue to submit that intentionally, right? That could be a knowing false claim that you're submitting. You're going to want to assess the scope of the problem. Is this an isolated event, or is it an extensive problem? Does this particular problem indicate a larger situation out there that you need to address? Was this knowing misconduct, or was it an innocent error? That may depend, factor into how you address this, whether you go to the OIG self-disclosure protocol or just handle through report and repay to the CMS fiscal intermediary. You may want to consider involving an appropriate attorney at the risk of trying to drum up business, or at the risk of sounding like I'm trying to drum up business. Make sure you're dealing with somebody who knows the federal fraud and abuse laws, who can help you determine whether or not there really is a violation. Hopefully your attorney understands those things. It may provide you with some protection down the road if you act on the advice of, if you get an attorney involved and you act on their advice. Not an absolute protection, but it may mitigate your damages. And it may maximize the attorney-client privilege. If you're doing the investigation, you want to do it under attorney-client privilege. Make sure that you immediately investigate if you think that there's a problem. Again, if you want to maintain privileges, you may have that investigation directed by an attorney, but it's not absolutely necessary if you don't want to. Remember that you got that 60-day deadline, and you've got to act with reasonable diligence. If you don't, then that 60-day deadline triggers immediately. So you're going to want to immediately take steps to preserve relevant documents, including electronic files, because if you destroy relevant documents while the investigation is pending, that could be the basis for additional penalties. Gather and review relevant documents, interview relevant persons, and document that. Again, if you may want to do it under attorney-client privilege so that you maintain the confidentiality if you need to. You're going to want to document that you did an appropriate investigation and that it was timely and reasonable. But, assume that whatever you document is going to be discoverable. Hopefully you can keep it confidential, but assume that it's going to be discoverable, so make sure that your language is appropriate. Never retaliate against whistleblowers, including those who bring these issues to your attention. You should determine whether a violation has occurred after you do that investigation. Again, involve qualified persons in that analysis. Review the specific requirements relevant to those regulations, including regulatory definitions, the requirements or elements for violations. limitations, exceptions, safe harbors, advisory opinions, commentary, things like that that will help you determine whether there truly was a violation. Did the transaction involve federal program payments? If it does, then there is a lot higher risk because you've got to deal with those federal programs that we talked about. For anti-kickback or CMP violations, was there an intent to induce referrals? If there was no improper intent, then technically there is no violation, but with that said, it may be difficult to disprove. Ensure you're applying the appropriate version of the regulations. Those regulations, a lot of them have changed over time. For example, the anti-kickback statute in Stark went through significant revisions in 2021. So when you're looking at your arrangement or analyzing compliance, make sure that you're analyzing under the applicable regulations. Make sure you consider official commentary and decisions relevant to the compliance issue, again, like advisory opinions, the preamble regs, etc. Note also, this is kind of a recent development. The current Supreme Court that we have has really cracked down on a government agency's issuance or reliance on sub-regulatory guidance when they really didn't go through a formal rulemaking process. And it may be that the sub-regulatory guidance is not enforceable anymore. So that's something you may want to discuss with your attorney. There is some argument under the Medicare Financial Management Manual that as long as the actor acts without fault, that they're not going to be liable for a repayment. But that's somewhat complicated and it's kind of been undermined with some other stuff. So you may want to consider that as a potential defense, but just don't rely on it. If there is a problem, make sure that you fix it, modify your processes, discipline appropriately your employees, execute, revise, or terminate improper referral arrangements as appropriate. If there's a Stark issue, require repayment by the end of the period of that 90-day reconciliation period. And then you're going to want to document your remedial efforts. Remember that simply fixing the problem going forward does not resolve the problem, right? If you receive an overpayment, just fixing it prospectively, well, that's all good and well for everything that happens in the future, but you've still got an obligation to report and repay violations in the past. Implement and document voluntary corrective action plan to avoid similar problems in the future. If you confirm that a repayment obligation is due, then you're going to want to make sure that you timely report and repay the overpayments within the 60-day time period, after you do an appropriate investigation. Consider whether you're going to want to go through the report and repayment rule, where you just report and repay to the fiscal intermediary. That's the preferred method, right? Unless you need to go through one of the other ways. If it's a Stark violation, consider the Stark self-disclosure protocol. For intentional or reckless violations of the False Claims Act, anti-kickback statute, or civil monetary penalties law, then you're probably going to want to look at the self-disclosure protocol. But you're going to want to talk it over with your attorney first, because there are serious consequences once you start down that path. When you do report to the government, make sure that you fully cooperate with the investigation. Don't misrepresent any information. Don't omit material information. Do not provide more than is reasonably relevant. Make your best case. Discuss adverse financial impact on your provider. Let the government know that, hey, this is going to put us out of business, and that means that it's going to adversely affect healthcare in our area. Assume the government is going to check any facts in your analysis. So, don't be careless when you submit stuff to them, because if you're careless or reckless in the information you submitted and the government concludes that you really didn't act in good faith or you lied to them, that is a bad situation. Assume that the government investigation may go beyond your initial disclosure to consider other issues. So, make sure that your house is pretty clean. When calculating your exposure, verify the actual payments received from the federal government programs during the relevant time period. I mean, it may be you've got a repayment, but look and make sure what amounts you really were paid, because you may not have been paid everything that you thought that you were. When calculating the repayment, use a credible methodology. There is no established or required methodology, but it's got to be reasonable under the circumstances. If the government comes in there and offers you a settlement, you're not obligated to agree to the settlement, but if you don't, kind of all bets are off and the government can come after you. So, be careful about those situations. All right. That is my relatively quick summary of the report and repayment obligations under the federal laws. If you want more information, you can go to the OIG's compliance website, where they've got lots of general compliance program guidance, including supplemental hospital compliance program guidance. Watch for new guidance that will be issued from the government. The government issued that general guidance They're going to be issuing industry-specific guidance for compliance programs. At this website, you can also access advisory opinions, fraud alerts, and special advisory bulletins, self-disclosure protocols, and the like. Make sure if you haven't, spend time in that new compliance guidance that the government's issued and compare it against your current compliance plan. And like I said, we've got a lot of content on our website that you can go ahead and access, including webinars on pretty much all things healthcare compliance. We've got client alerts, white papers, and the like. If you'd like to sign up to get our free client alerts talking about health law updates and these types of issues, just shoot me an email. We'll make sure you get added to our list. That is it. Good luck. If you have any questions, you can use the chat feature and submit those to him, and Luke will get those to me. Otherwise, you can email me, and I'd be happy to try to respond offline, although sometimes it takes me a few days to do that. Thanks for your participation, and I hope you have a good day and a good weekend.